3 words, in court, under oath. Say them slowly. I was assaulted. Not whispered, not implied, said out loud, on the record.
Incriminating information, but he says he was severely assaulted, tortured and questioned about the murder of the soccer star, which he knew nothing about in June 20.
Because in South Africa, those words do not just describe a moment, they change the entire room. If you want to understand how power moves, do not stare at speeches. Do not chase press statements. Watch procedure, because procedure is pressure. And this week, in the Pretoria High Court, that pressure cracked. The Senzo Meyiwa murder trial resumed, and instead of clarity, it delivered a new explosion. Not about the night Senzo was shot, not about who pulled the trigger, but about what happens after the handcuffs go on, about what police do when no cameras are rolling, about what a witness says when the system itself is staring back at him. A defense witness stood up and said something that instantly shifted the case. He alleged, under oath, that he was assaulted by police, including Ekurhuleni Metro police officers, and that they forced him to sign a statement he did not freely give. Zungu says the pressure did not happen in theory. He places it in real locations, with real officers. In court reports, he points to Ekurhuleni Metro police officers, and he describes being pushed into signing to make the ordeal stop. That witness is Sifiso Gwabini Zungu. Zungu is not a random name in this file. He sits at the intersection of both sides. He has told the court he is related to accused number 1, Muzi Sibia, through their mothers. And he has also challenged the version of a key state witness, his own uncle, Constable Sizwe Skumbuzo Zungu. And that family link is not just personal drama, it is courtroom fuel. Because every question becomes sharper. Is this witness protecting blood, protecting himself, or exposing a lie under oath? And here is why it matters. The state says that statement implicates accused number 2, Bongani Ntanzi. In other words, the state wants that statement to be a bridge between names, places, and timing, strong enough to hold accused number 2 inside the state's version of events. If the bridge is ruled unreliable, a key connection in the state's narrative weakens. The state's position is that this disputed statement is not just another piece of paper. It is meant to support the confessions of Muzi Sibia and Bongani Ntanzi, and to reinforce the testimony of the state's star witness, Constable Sizwe Zungu. That is not a minor allegation. That is a legal landmine, because once coercion enters the record, everything becomes unstable. Evidence, confessions, credibility, even the verdict itself. To understand why this matters so much, you have to step back, all the way back. Senzo Meyiwa was not just a footballer, he was the captain of Bafana, a national symbol, a man trusted to guard the goalpost for a country that has never stopped fighting for dignity.
Losing youngsters like this at the pinnacle of their career.
On 26 October 2014, he was shot and killed inside a house in Vosloorus. Police initially described it as a robbery gone wrong, but from the very beginning, the story never sat still. Too many people in the room, too many contradictions, too many delays. Years passed with no arrests. Public anger grew. Trust eroded. When 5 men were finally charged, many believed justice had finally caught up. 5 men are on trial: Muzikawu Hulelwa, Muzi Sibia, Bongani Mafika Ntanzi, Mthobisi Gadla Minkub, Mthokozi Seni, Mthokozisi Mafisa, and Fisokule Nkani Ntuli. They face charges including murder, attempted murder, robbery with aggravating circumstances, and unlawful possession of a firearm and ammunition. But instead of closure, the case turned into one of the most complicated and controversial trials in South African history, not because of what happened that night, but because of how the investigation unfolded afterward. Here is the timeline the court is now forced to untangle. Zungu testified he was confronted with documents at a police station in Primrose in June 2020, during a meeting led by the investigation team. He testified he signed without knowing what was inside, after he had already been assaulted. This case has shifted into a fight about admissibility.
But what I do see from my side is somewhat a desperation from the side of the state. If you had a strong case in which you're able to prove all the elements in that particular crime, confession or not, you'd have been able to prove this particular case. So the mere fact that you're fighting over it and trying to make sure by all means that it is accepted, then it means that you may see that your chances of actually winning in this case.
Not guilt, not innocence. Just one question. Can the court trust how certain statements were obtained? The judge has stressed that this is not formally a trial within a trial at this stage, but he has also said he cannot rule on the statement without hearing from the officers linked to the assault allegation. The judge's move here is the headline behind the headline. He cited Section 186 of the Criminal Procedure Act, a power that allows the court to subpoena witnesses when their evidence is essential to a just decision. In other words, the court is not waiting for the parties to volunteer the police. The court is saying it needs them. A pause on guilt or innocence, so the judge can first decide whether certain statements were obtained lawfully. This is not the court deciding who is telling the best story. It is the court deciding whether the method behind the story was clean enough to be used at all. And if it was not, that statement can lose weight or be kept out entirely. Several accused men have testified that they were assaulted by police, that they were suffocated, beaten, threatened, that confessions were extracted, not volunteered. Those claims alone shook public confidence. But this week, the pressure escalated again, because now it is not just the accused speaking, it is a witness. Because when a witness, not an accused, puts coercion on the record, the blast radius spreads. It stops being only about defense tactics and starts looking like a system problem the court cannot ignore. Sifiso Gwabini Zungu took the stand as a defense witness, and what he said landed like a thunderclap. He denied that he willingly made a statement implicating one of the accused. A key state witness has claimed Zungu's room at the Basotho hostel was used to plan the murder, and that the accused reconvened there after the shooting. Zungu has denied that version. If that scene is true, it anchors the state's timeline. If it cracks, the whole timeline wobbles. He told the court that police officers assaulted him, that he was intimidated, that he felt forced to sign documents he did not properly read or understand. The courtroom went still. Then came the detail that made it feel real. Zungu was shown aerial images of the Vosloorus Municipal Precinct. He pointed out the exact spot where he says he was assaulted by Ekurhuleni Metro Police officers. Here is the chilling overlap. EWN reported that the spot Gwabini pointed out is almost the same spot accused number 1, Muzi Sibia, previously pointed to when he alleged he was assaulted into signing his own confession. Two different people, one location, same allegation, because when a witness says that not an accused, not a suspect, but a witness, the implications spread outward fast. The defense seized on it. This, they argued, is not an isolated incident. This is a pattern. The state immediately pushed back. The judge has already ruled that the state can cross-examine Zungu on that prior statement, treating it as a previous inconsistent version. And this is where the tension becomes procedural. The prosecutor, Advocate George Baloyi, has been pressing Zungu on contradictions, especially on whether his constitutional rights were properly explained before he signed. The state pushed a document in front of him, a form meant to show his constitutional rights were explained. The defense objected on a simple but deadly detail. The date on the form did not match the date Gwabini says the investigators confronted him at the station. In cases like this, a single day can decide whether a statement stands or collapses. Prosecutors challenged Zungu's credibility, pointing to inconsistencies in his testimony. They questioned why he did not immediately report the assault. They suggested his version of events shifted under pressure. This is where the trial became something else entirely, because the judge did not brush it aside. Instead, Judge Ratha Mokwadalheng leaned forward and made it clear. These are serious allegations. So serious, in fact, that the court has indicated it must hear from the police officers accused of assaulting Zungu.
Mr. Kwabeni, who was still in the witness box, my lord.
Where is he?
I will arrange that he be ushered into the box, my lord. Thank you.
That matters, because once police are called to explain their conduct, the spotlight flips. The investigators become the investigated, and the case stops being only about Senzo Meyiwa's death and starts being about the integrity of the justice system itself. This is not about emotion, it is about law. South Africa's constitution is clear. Statements obtained through coercion are not just unethical, they are unlawful. If a statement is forced, it can collapse an entire prosecution. That is why this moment is dangerous for the state, and why it is powerful for the defense. But it is also dangerous for public trust, because this case has been watched for over a decade, by a country still waiting for answers, still waiting for accountability. And now, once again, the question is not, who killed Senzo Meyiwa? The question is, can the system prove anything cleanly? Security concerns have already hovered over this trial. Then the courtroom energy changed mid-sentence. Times Live reported that, while advocate George Baloyi was still addressing the court, officers walked into the public gallery and removed 3 men. Gwabini interrupted the proceedings, saying people who were with him had been taken and the court had to break while lawyers met the judge in chambers. Police spokesperson Athlenda Mate said SAPS had received solid intelligence about a group attending court with the intention of targeting key role players on the side of the state, and that security was heightened. A case of conspiracy to commit murder was opened, according to police statements reported at the time. Whispers of intimidation have followed witnesses. All of it adds to a sense that this trial is walking a tightrope, and the tension is not theoretical. The rope is fraying, and then comes the part that makes the fear feel current. It has been reported that Zungu was shot last month in KwaZulu-Natal, raising questions about witness safety and whether he would even return to court. What happens next is critical. From here, the case splits into 3 possible routes. If the officers testify and the court finds coercion credible, the statement can be weakened or excluded. If the officers deny it and the paperwork holds, the state will argue the statement stays in play. And if doubt lingers, the trial slows again, because procedure has to be cleaned before the court can move to guilt or innocence. First, the officers linked to the alleged assault may be subpoenaed and called. Then, the judge will decide what weight, if any, the disputed statement can carry, or whether it must be kept out. And if that statement falls, the state has to lean harder on whatever independent corroboration it can prove in court. And if the case weakens, so does the promise of justice that South Africans have been waiting for since 2014. This is why procedure matters. This is why pressure matters. Because in this courtroom, the law is not just deciding guilt. It is deciding whether the system itself can be trusted to tell the truth. And that decision is still unfolding.